Hey everybody, Valerie Zametti of Zametti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Today we're going to talk about how to change your estate plan during the pendency of a divorce. Before we get there, however, if you have any estate planning or probate questions, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. So if you or someone you know is in the process of a divorce and they have an estate plan in place or don't have an estate plan in place, but are concerned with who would make decisions on their behalf if, God forbid, they fell ill, or of course, how to handle their assets if they should pass during the pendency of the divorce, you want to address those things one by one. I've actually seen in past experience where unfortunately a woman was ill with cancer and she didn't have long to live. She was also in the middle of a divorce. And because she did not get her estate plan updated beforehand, many of those assets wound up with her divorcing spouse. So a few things. One, you do have to look to state law because there's sometimes restrictions. You also have to look at federal law. There are sometimes restrictions as to what you can change when with regard to distributions of assets. However, at the very minimum, what you should initially address is the usually higher likelihood of a potential incapacity as compared to your passing, although both are possible, and address who would be your decision makers to handle your finances, handle your medical decision making under those documents, a power of attorney and a health proxy. You certainly, or in most circumstances, not all, but you probably don't want that ex to be the decision maker as they may have been before. And while you're still married, technically, they may have some rights to be that decision maker, even if that's not whom you would want. So seek counsel, make sure you update at minimum your incapacity planning documents during the pendency of your divorce. And I know that's a lot to swallow because there's a lot going on during that time. But if you think of it this way, it will relieve you to know that it's someone other than that person you were separating from who will be making those decisions for you. In addition, when it comes to the final distributions, again, it does depend on state law and the circumstances of your separation or divorce. But there may be ways to exclude your spouse despite still being married if the circumstances fit and state law allows under your estate plan. So if you're stuck in a situation where your divorce is taking a very long time, which is not uncommon, then you may want to address those items as well. As a reminder, if you have any estate planning or probate questions, you can reach out to us for a free conversation at yourplanningattorney.com. Thank you so much for watching, and if you found this information useful or think others may, please share, like, and subscribe where appropriate so nobody misses out. I'm Valerie Zametti of Zametti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Take care.